Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello beautiful people, welcome back to our channel. And as Nigerians are waiting earnestly to hear the final verdict that may likely be given by Justice James Omotosho in Nnamdi Kanu's case versus the federal government over so many issues, of course. And there have been a lot of radar on not just Justice Omotosho, but the judicial system in Nigeria. Don't forget, just fairly recently, Donald Trump, the United States of American president, had talked about the issue of insecurity and what people are saying and what the president of Nigeria, Bola Tinubu, responded. But let's quickly dive into the newspaper to find out exactly what is going on with the verdicts at stake and Justice James Omotosho at the center of it all. But before we go into the newspaper, kindly subscribe to our channel. Now, according to what we are gathering, 1 month after President Bola Tinubu proclaimed the state of emergency over Rivers State last March, on 18 April 2025, former Rivers State Governor, Minister of the Federal Capital Territory, and life member of the body of benchers, Wike, held one of his beverage-powered media encounters in Abuja, during which he proclaimed with characteristic exuberance that his successor as governor, Siminalayi Fubara, should thank Mr. President for the emergency proclamation. Now, as at on October 22, 2025, this line officially made it into Nigerian jurisprudence when James Omotosho, a judge of the Federal High Court of Nigeria, decided in suit number FHC/PH/CS/53/2025 that the plaintiff should be grateful that the president proclaimed the emergency over Rivers State, that the messenger through whom these words have now officially become law in Nigeria offers important insight into what has become the faith of judicial office in the country. When he terminated the emergency rule in Rivers State in September 2025, President Tinubu took time to acknowledge over 40 cases in the Port Harcourt and in the court in Abuja, Port Harcourt and Yenagoa, filed to challenge the declaration, noting with a touch of presidential menace that some cases are still pending in the court as of today. On 22nd of April, James Omotosho decided one of those pending cases. Now, the plaintiff in the case was Samuel Amatonije, who described himself as a resident and registered voter in Rivers State, as well as a member of the Nigerian Bar Association, NBA. That means he is also a lawyer. And the 6 defendants in the case, including the President of Nigeria, the President of the Senate, the Speaker of the House of Representatives, the Attorney General of the Federation, the National Assembly, and the military administrator of the emergency rule. Although he filed the case at the Port Harcourt Division of the Federal High Court, Mr. Amatonji's case traveled inexplicably to Abuja, where it inexorably ended up in the court of James Omotosho again, a judge whose fixation with all matters in which Wike has even the most tangential of interest has become plainly pathological. Some extent is essential here. In October 2023, a mere 5 months after the end of Mr. Wike's tenure as governor of Rivers State, the State House of Assembly, the site of an early attempt to remove the governor, suffered a sufficiently timed fire incident. It became evident that the relationship between Mr. Wike and Siminalayi Fubara, his hand-picked successor, was hopelessly fractured. In the wake of that, the state legislature splintered into 2 factions, respectively loyal to the incumbent governor and to his predecessor. On 6th of November 2023, the faction loyal to the governor headed to the Federal High Court in Port Harcourt, the state capital, seeking judicial legitimation of his claim to being in lawful control of the parliamentary gavel. Now, they applied in proceedings intended to be held without the other parties present, that's ex parte, for an order to restrain the other faction from interfering with other conduct or with their conduct of legislative duties. Delivering her ruling the following day in suit number PHC/PH/CS/240/2023, Phoebe Ayua, the presiding judge, declined this application, required that all sides be put on notice for a full hearing, and ordered that the parties should not take any step concerning the subject matter, since the matter is already before the court. 3 weeks later, on 29th of November 2023, while this order remained undischarged, Martin Emefiele, the Speaker of the faction in the State House of Assembly, loyal to Mr. Wike, and himself a named defendant in the proceeding before Justice Phoebe Ayua, filed suit number PHC/FHC/ABJ/CS/1613/2023 before the same Federal High Court in Abuja on the same subject matter. Like the previous suit, Emefiele sought judicial legitimation of his factional claim to control of the Rivers State Legislative, asking the court to restrain federal authorities and institutions as well as the governor of Rivers State from exerting financial and other pressure on them, ensuring release to them of all federal allocations standing to the credit of the Rivers State House of Assembly. As with the previous suit in Port Harcourt, the plaintiffs in the case before the Federal High Court invited the judge in Abuja to grant them this relief without hearing the named defendant. The following day, on the 30th of November, James Omotosho, again, the judge who presided over the proceedings in Abuja, ruled swiftly, and unlike his colleague in the Port Harcourt case, promptly granted all the relief sought without hearing any other person. Now, this was not the first time that James Omotosho will be granting curious orders that support the political interests of Mr. Wike. In the month originally preceding the governorship election in 2019, he issued an order restraining the All Progressive Congress (APC), the main opposition party in Rivers State, from presenting any candidate in the governorship election, all but ensuring that the governorship election in the state was Mr. Wike's electoral non-evident. In February 2023, James Omotosho again issued another order restraining the People's Democratic Party (PDP), who were not afforded a hearing, from taking disciplinary measures against Mr. Wike on allegation of anti-party activity. Now, in January 2024, James Omotosho voided appropriation in Rivers State and issued a most remarkable of a la carte judicial orders restraining the state governor from frustrating Emefiele faction of the House of Assembly loyal to Mr. Wike. On the last day of October 2025, the same judge, James Omotosho, struck again in proceedings filed by Mr. Wike's loyalists, granting them an a la carte order to invalidate the proposed National Convention of the PDP by restraining the Independent National Electoral Commission (INEC) from attending or recognizing it. The sheer range of the magnetic forces that bind this judge, James Omotosho, with Mr. Wike's interest is well beyond ordinary laws of both physical and of judicial administration. Those forces were all full advertisement in this adjournment of Samuel Amotoji's case. First, the judge held that he did not have jurisdiction over the subject matter. Next, he held that Mr. Amotoji lacked the standing to bring the case anywhere. Indeed, the judge held that the case was so void that the originating process ought not to have been accepted for filing, let alone wasting the precious time of the court. The case ought to have ended there, but the judge would not be assuaged, and his judgment, enthusiastically supported with the authority of Wikipedia, swiftly descended into force. Turning to the requirement for the National Assembly to approve emergency rule by a joint resolution of 2/3 majority, the same James Omotosho ruled that nowhere in Section 305 of the Constitution is there any specific method for reaching this resolution, and therefore that if the National Assembly in their discretion decided to use voice notes in approving the proclamation, they are within their constitutional powers to do the same. The man has his unique Omotosho-ish vision of the Constitution. Having held that he lacked jurisdiction and the claimant lacked standing to bring the case, James Omotosho, however, dismissed the case, but he reserved his best for last, resounding rounding off with an audacious act of judicial malpractice by imposing cost of 9 million naira on the plaintiff in favor of respondent, each of whom was sued in institutional capacity. The only thing more brazen than the jurisprudence or the others that emanate from Court of James Omotosho is the predictability with which all cases affected the political interests of Mr. Wike and the Federal High Court probably ends up on his docket. That is a matter of a la carte law, which can only be explained by the troika of Mr. Wike, his favorite judge, and the current chief judge of the Federal High Court. 190 years ago, when he wrote the classic Democracy in America, Alexander de Tocqueville decided to devote a chapter to judicial power, which he described as political power of the first order. In the Court of James Omotosho, de Tocqueville finds his proof as well as the falsification of his thesis. The ends may be political, but can that also be said of the means by which they are procured? Now, all of this, of course, is coming from none other than our very own Professor Odinkalu. We have been observing over time that is one professor who will not keep quiet. No matter whose horse is being God, he will speak his mind. Here it is. James Omotosho now is handling Nnamdi Kanu's case. The question is, will there be a James Omotosho touch in the case? Time will